confirm that the name on the screen is correct if there is one, or just give me your full name and then tell me who you're representing here today. If you're connected to the project somehow, whether you're the property owner or applicant or someone else, or if you're a neighboring property owner or anyone else related to the project. So I'll start with John in the top left there. John, you'll need to unmute.
Yeah, hey, I'm John Blatt. I'm a neighbor of the property. I live at 33473 Principio Avenue.
All right, great. And you said Blatt with a B?
Yeah, Blatt.
Got it. All right, welcome. I see we have two folks from RWA here.
Hi, yes, I am Jordan Martis,
And I'm Mike Malk.
and we're representing the property owner at 3453 Principio.
Great. And you said Jordan Mattis?
Martis, Mardis, like Mardi Gras.
Got it. Awesome. All right,
And
thanks.
Mine is Mauch.
Got it.
Thank you.
Okay, welcome. Thank you. Molly Brugge.
Right here.
Hi. And are you
I'm
sorry, you're the property owner.
I'm the property owner, yes.
That's right. Welcome back.
Thank you.
And let's see, your husband is here too, right? Kevin?
Yeah, Kevin Brugge.
All right. Welcome back.
Thank you.
Okay, Gina Blatt. Gina, are you with us? If so, if you could just unmute. Okay, while she's working on that, we'll go over to JP Burley. Welcome, JP. You could unmute.
Good afternoon, Mr. Examiner. My name is JP Burley. I'm with the law firm of Studer LLC, and I'm here with Mr. Anthony and Lori Wood, who own the adjacent property at 3459 Principio.
And welcome. Right. We also have Taylor Trout here. Mr. Trout, are you with us?
I am. Good afternoon. Taylor Trout. I'm an attorney at KMK Law, and I represent the Brugges,
Okay. Great.
the
Welcome.
applicants. Thank you.
Yep. Got it. All right. And we also have Wes Munzel here from the City Planning Department. Welcome, Wes.
Good afternoon.
And Arlie Sherman.
Hi, Sherman. My husband and I are adjoining property owners at 1264 Hayward Avenue.
Okay. Hayward, you said?
Yes,
Okay. Welcome.
thanks.
All right. Ms. Blatt, are you with us?
Yeah, am I unmuted now?
You are, yes.
Okay.
Yep.
Yes, I'm at 3473 Principio Avenue. And a neighbor, I can view the property from my windows.
Okay. Got it. All right. Welcome. On the applicant owner side, are we expecting anyone else to join us here before we get started?
I think this is everyone.
Okay, fantastic. All right. I need to read through our hearing script. This will just cover the procedure for the hearing, and then we'll get into it. So this is the August 7th, 2024 session of the Zoning Hearing Examiner docket. My name again is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati. The case before us today is case number ZH20240092. That's 3453 Principio Avenue. The purpose of the hearing is to allow applicants and any other parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the Zoning Hearing Examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. Now, Mr. Trout, I'm pretty liberal about how you want to orient your presentation. If you want to do a more traditional sort of direct examination of your clients and ask them questions, you can do that. Or if you just want to turn the floor over to them to present, you can do that as well. I'll allow you to sort of quarterback the whole applicant presentation if you would like, or have someone else if you would like. But after you're finished with that presentation, I will then turn it over to public comment. That'll be an opportunity for anyone here from the public who is not represented by an attorney to provide any testimony that they would like. If the applicant is represented by an attorney, which they are in this case, The applicant's attorney may cross-examine any person who testifies at the hearing. If a party of record is represented by an attorney, and that is the case here today, Mr. Burley is representing the Woods as a party of record. The attorney for the party of record may present witnesses after the applicant has presented its case and may cross-examine any person who has testified at the hearing. In the event that any party testifies or offers argument in opposition to this application, which we already have a written opposition, the applicant will then have an opportunity to rebut the testimony and or argument that was offered in opposition. So Mr. Trout, you'll have an opportunity for rebuttal after Mr. Burley makes his presentation. And then finally, the applicant will be given an opportunity, the attorney for the party of record, Mr. Burley, will then, after rebuttal, have an opportunity to make any closing statements. And finally, the applicant will have an opportunity to make any closing statements. I know that was a lot. I'll keep us on track here procedurally, but that's the general outline. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or make any comments. In the event of technical difficulties with the Zoom technology, I'll do my best to troubleshoot those issues on the fly. But to the extent there's some defect that prevents us from really meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. All right. Last thing I want to do here before we get started is swear in all of our witnesses. So if you are intending on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing, and you are not an attorney, the zoning code requires that I swear you in. So I'd like to collectively do that with everyone right now. So again, everyone who's going to provide any testimony here today and not just observe and is not an attorney, if you could please take yourself off of mute and raise your right hand. I'll need everyone to answer out loud. Do you swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Yeah.
Great. Thank
I
you,
do.
everyone. Okay. All right. Mr. Trout, are you ready to proceed?
I am, yes.
Okay, great. The floor is yours.
Wonderful. Good afternoon, everyone, and thank you, Mr. Sturkey. Initially, I am still fighting a cough. It's been going on for a month. I don't know why, so I apologize if occasionally I mute myself to cough or if I trail off. If you can't hear me, just yell at me. I'll speak up. Again, as I've said before, my name is Taylor Trout. I'm an attorney here at KMK. I do have the honor and pleasure to represent the Bruggies in this application process, which obviously is why we're here today. There's been several written and documentary submissions in this matter. My intent today, my goal today is to not just simply restate everything there. It's already part of the record. I don't want to beat a dead horse and just sound like a broken record on some things. RWA Architects has done a wonderful job in their submissions. I don't think that we need to really repeat all of that stuff. They will speak. And Mr. Sturkey, to your point, I intend to just talk a little bit now and then frankly hand it over to RWA and to Molly Brugge to present their side of the story as well and some information. I do want to highlight a few things, as I said, before turning it over to them, turning the floor over to them. And there's some matters that have been raised that I do feel the need to address off the jump here. By my math, and RWA and Molly Brugge can confirm this, but an RWA submitted an updated map as to this, but there has been 18 separate submissions of approval from neighbors or other property owners in the area. And there were, I believe 3 property owners who opposed, either currently opposed or opposed in the past. Like I said, they sent around an updated map, and I find that particularly helpful because they have highlighted in green those property owners who have written in support, and some of whom are graciously taking time out of their day today to speak as well. By my math also, and again, RWA, Molly can correct me on this, and this is notable, there are 5 adjacent property owners, or meaning owners of property that touch the Brugge's property, 4 of whom are in support, 1 of whom are here today represented by counsel in opposition. If you count the property owner who lives directly behind the Brugge's, they are also in support, so that would be 6, 5 in support, 1 in opposition. I think that's notable. Again, that map I think provides a pretty good visual as to that. The one neighbor who opposes Anthony and Lori Wood, again, here represented by counsel JP Burley. I'll call them the Woods since that's how it was they were referred to by JP in his letter. Submitted an opposition, and they really gave opposition for one reason only in their written submission. And their claim is that the variance request should be dismissed or denied based upon issue preclusion or res judicata. Mr. Sturkey, you're obviously familiar with those terms, but it's really just a fancy way of saying this has already been decided. You shouldn't decide it again or consider it again. Ohio law is clear, though, that res judicata does not prevent a new application or a new variance request when there is a change in circumstances. And that's exactly what happened here. There's many examples of what constitutes a change in circumstances, but there's none clearer than a change in law, or here, a change in the zoning code. RWA outlined this change, and we'll refer to it probably several times today. And the primary one that we'll talk about is the Cincinnati's adoption of the accessory dwelling unit ordinance, or the ADU ordinance. The ADU ordinance is the significant change here. And it permits the Brugge's to do exactly what they are wanting to do here, and frankly, a lot more, other than connecting that ADU to their primary residence, which is why we're here for the variance. We want to connect that accessory building to the primary residence. In fact, the ADU allows it to be built as close as 1 foot from the residence without connecting it. And it actually allows the building to be built closer to the Woods property, taller than what they're requesting. For example, they could build the unit 2.5 feet taller. They could build it 9 inches closer to the Woods property line. The ADU is a standalone rentable unit. Now, you'll hear from Molly and you'll hear from RWA that they don't intend to rent this unit. What they're truly intending to do is accommodate their growing family, their larger family, to make it more conducive for their living, but also to accommodate the future, and that future is near for their aging parents, for when, if and when they're in need of assistance. Molly can obviously discuss that a little bit further, but recognizing this, the ADU ordinance is a change in circumstances. Mr. Munzel, Weston Munzel, authored a staff report in which he specifically and correctly stated that the ADU zoning code text amendment is considered a substantial change to the zoning code that impacts the overall review. In other words, the ADU code change constitutes a change in circumstances such that res judicata does not apply. Wanted to address that right off the bat, just so that there's no question on that issue.
So Mr. Trout, real quick. So you're saying, despite the fact that this is not proposed to be an ADU, and is not being reviewed under the ADU standards, the change in law to make ADUs legal and easier to build should be considered when reviewing this project. Is that right?
Yes, particularly with respect to this res judicata issue, because it is a substantial change in the zoning code. And as I said, and I can elaborate further, as can RWA, but they would be able to do exactly what they're doing now, pursuant to the ADU ordinance, minus the connection of the primary residence and the accessory dwelling. That is the only difference here. And they could do far more. So any argument that it impacts or negatively impacts any of the neighbors, for example, this variance would negatively impact any of the neighbors, is simply untrue, because the ADU theoretically would impact them far more if they were to build it to the potential of what they could do. than what they're asking for here. So what they're asking for as far as a variance goes is less intrusive, less impactful upon neighbors, upon adjoining property owners, upon the neighborhood than what they'd be allowed to do under the ADU ordinance.
Got it.
To highlight a few things that I think have been raised previously or have since been raised, and to try to give a conceptual understanding of why they're requesting to do this, the Brews are requesting to do this. Just to make it abundantly clear, this isn't a situation where the Bruggies are trying to improve the value of their home or improve the value of their property with the intent of simply turning around and selling. It just isn't the scenario. They're good people. They're a good family. They're a family that has just simply outgrown their home. Family that frankly cares about their neighbors, cares about the neighborhood. I think that's pretty well exhibited by the number of people who have written in support, and that there are people here today taking time out of their busy schedules to talk on their behalf. They love Cincinnati. They love their neighborhood. They've already invested, including the purchase price of the home, upwards of, if not in excess of, $1,150,000 in this property. The auditor currently has it valued, and don't quote me exactly on this, Molly can elaborate, or at RWA, somewhere in the $800,000 figure. They have a lot more money in this property than what the property, according to Hamilton County, is valued. This isn't about adding value to the property. This is about making the home conducive for their family so that they can stay there. They'll never get out of the home the value of what they're going to put into this to make this home conducive for their family. It's an expensive endeavor. It's an expensive project, and they just will never get that value out. Make no mistake, though, too, they've explored several options of making this home more conducive for their family. They explored building a basement under their home. They have a crawl space currently. They hired RWA. They rendered drawings. They got structural engineer opinions. They hired a contractor to come in and look at it. And the overall opinion of all of them was it just is not practical. There's significant structural concerns that would be caused by adding a basement and a lot of other impractical aspects of it. They've explored options. This is what they're left with. If the variance isn't approved, they're frankly left with two options. They're left with the option of building the ADU, which they, under the law, could potentially just turn around and rent it out to third parties, or move. Building the ADU, though, and I've mentioned it a couple times already, has negatives that also make it impractical. For example, safety. When we're talking about safety issues, and Molly will elaborate on this more, but connecting the two structures reduces significant risk and safety concerns for their children of traveling back and forth between the two units. It reduces risk of even non-supervision because it'll be connected. It'll be easier to supervise children, to supervise their parents when their parents move in, for Molly to take care of them. Their parents are going to have to travel back and forth, and going outside for a 1 foot gap between the two does add risks for them. Inclement weather on the outside of between the two creates factors and safety factors and issues. If disconnected, they'll have to add additional things to ensure safety. For example, floodlights. I think perhaps RWA has already addressed this, but they'll have to add floodlights, which frankly would probably impede upon the Woods property could, with light pollution or light shining into the property far more than it wouldn't at all if the units were connected. Sound and noise, for example. Children going in between the buildings. If it's connected, you won't have to worry about that. If it's not connected, you're going to hear the children, the family going back and forth. Having the ADU too, and I think that at some point in time, it was expressed to me that this was a concern of one of the neighbors. Having the ADU, like I've mentioned, you have the ability to rent, not just them, but and that's not what they want to do. But if they were down the road to sell the property, then the next property owner would be able to rent that out to some third party. Allowing the connection of the building rather than a simple 1 foot gap is it's just simply the logical answer here. That's particularly true because of the way in which the driveway currently exists, the driveway apron, the garage doors, the inability that I mentioned to build a basement, and other reasons that RWA has already conveyed and that they'll convey. And Mr. Munzel recognized this in his staff report as well, stating that the application in the Brugge's situation is a unique situation, and that strict interpretation of the code would be unreasonable and would result in practical difficulty in construction of a functional addition. A few other items that I'll mention before handing this over to Molly and RWA is there is a property directly across the street at 3440 Principio. It's directly across the street from the Brugge's property. They were granted a variance that's exactly the same type of variance that the Brugge's are requesting here. That they be allowed to connect their dwelling, their residential dwelling, to an accessory dwelling. They were granted, they requested it, they were granted that variance. It's the same exact variance being requested here. One of the letters.
What's the address on that one?
3440 Principio. And Mr. Munzel does address this in his staff report as well on it's towards the end. Page
Real
12.
quick, just so I'm thinking of the right thing here. Wes, was this the one with the pergola structure that was installed?
I'd have to check which address you're talking about.
3440. It's all right. I'm sorry to interrupt, Mr. Trout. You can keep going. I think I do remember the property question, but I'm sorry. Go ahead, Mr. Trout.
No, that's fine. And just for the record, it's, you know, the connection is what matters. That's what requires that variance. It doesn't, the code does not differentiate between what the connection is or what the connection looks like. It doesn't matter whether it's a 2x4 that connects the garage to the home or an entire enclosure, brick, mortar, siding, whatever. It's the simple connection of it from the variance perspective and from the code perspective that matters.
Right.
And I'm happy to answer more of those questions. RWA is also keenly aware of that, and they'd be able to address it very well also. One of the letters that came in support for the Brugge's did have a notation in it requesting that any potential runoff issues be addressed. Excuse me. Molly can discuss that and address that issue head on probably better than I can, but the plans that RWA has designed and some of the landscaping plans that go with it do already address that. And Molly will be able to explain that there's actually additional steps that are being taken to, frankly, not necessarily address any potential additional runoff caused by this addition, because I don't think there really are, but to do the neighborly thing and try to help their neighbors deal with runoff issues too. It's something that the Brugge's experience as well. So there's already things in place, plan in place to go above and beyond to address those concerns. It's the neighborly thing that they're doing. Ultimately, Mr. Munzel's recommendation in his staff report, and it was after he performed a detailed and thorough analysis as to everything that was very well written, is to approve the Brugge's variance request. And today that's what we're here to ask, is that you adopt his recommendation and approve the variance request. At this point, I would like to turn this over to RWA to kind of fill in the blanks and perhaps address some of the more technical side of the variance request. They're the experts on this, so it's probably better to hear from them on that. And then after they speak, I'd love to give Molly an opportunity to fill in the blanks of some of the things that I discussed also.
Turn it over to RWA.
Thank you, Taylor, and thank you, David. Something that I did want to correct from what Taylor said was that they don't have a basement. I did want to state that they do have about 1/3 of their house is basement and the other 2/3 is crawl space. So they do have a little bit of basement space that we did actually work with them to look into different design options for that basement space. And like Taylor had said, they talked to a contractor and explored ideas for that, but it ultimately was not recommended because it structurally was not safe to underpin in order to get to a safe head height in that basement. So that was not recommended. They also looked into other locations on the site. Mr. Sturkey, do you mind if I share my screen? It might help to kind of show what I'm talking about here.
Sure. Yeah, go ahead.
Thank you. Let's see, not this one. Okay, so here's the site plan. This is our existing detached garage, and we are proposing a second floor addition on top of that with this connector piece to attach to the existing residence. In terms of other locations on the site, they also looked into building within the setback area over on this east side where they currently have a concrete patio and a covered porch here. But ultimately they decided that that wasn't the best option because one, it would be in closer relation to the neighboring property, and also it would be more visible to the street. Whereas this is a little bit further back. It's the existing garage is 55 feet away from the nearest point of the neighboring property, and with the addition, it'll be 50 feet away from the neighboring property. They also looked into building on the west side, which they cannot because there is a sewer easement here, so they cannot build on top of that either. They also looked into building onto the rear of this here, but that would, as you can see, require a rear yard variance. So we would kind of run into this same issue, and also it would prohibit the use of the garage and not be as convenient and tie into those safety concerns with close proximity for the children and or the in-law suite. Another thing that I wanted to touch on and correct, I'm sorry, just one moment, please. Lost my train of thought. Actually, that's all I had. Do you have another?
Just that, I think that we talked about the other, the ADU idea. The city marketed and sold this idea of an ADU. Other cities are doing it. One of the reasons is so that people don't have to move if they have a relative that needs to be close by and taken care of. They can build a structure so that their aging parents or child that needs care can live close by. And that's to us, part of this idea here is that connecting it allows for safer conditions should that time arise when they need their parents, one of their parents to live there. Also, while their children are there, as mentioned earlier, so that they can hear and quickly get to anyone who needs assistance in the area above the existing garage without going outside and slipping on the ice or any of those sort of things. So the city is encouraging this. They're promoting it. They passed an ordinance for it. They do not want people to move away. They want them to stay in their house. And hence, if this work can be done, the Brugge's have every intention of staying in this house.
So, if I may, I wanted to show the map that Mr. Taylor Trout was mentioning too, with the neighboring properties here. So this is a map showing all of the green is the neighbors who have signed in support, whether that be last year or this year. The dashed circle is who had signed in support previously, and all the green is who have signed in support recently this year. The woods here at this property were who have submitted their opposition statement. And then these two other neighbors in the red were who submitted statements opposing last year, but have not seen any recent statement in opposition this year. But I think it is important to note, like Taylor said, that you can see all of these other adjoining neighbors in the green. Especially you can see, I want to say the Blatts live in this property right here, and they have a direct view of the proposed addition outside their west windows and can see that directly. There is a bunch of foliage that is on this side, so maybe this neighbor is probably not as affected, but again, they do still support. So I think that was important to note there too.
While we have this one up, if I may, take control of the mouse. This person here is in opposition, can't really see this. They'd have to look through this house to get any kind of view of this. This one, same thing. It's much further away, but still a line of sight to this area right here is blocked by these other views. So maybe they oppose in some sort of theoretical idea, but it certainly isn't that it's impacting them by looking at it or being close to it, or somehow negatively impacted by the connection of these two structures.
I also wanted to note that this is the neighbor here at 3440 Principio that received that approval of the variance to connect their detached garage to their existing principal structure. And then this neighbor also directly across the street, they have submitted a letter of support as well. And they actually can directly view and see a portion of that addition as well.
Okay.
Is everyone following that?
Yeah, I
thank
followed
you.
perfectly well. Yeah.
Thank you.
Thank you.
If I could just ask a couple questions of you two. I had gave a couple statements and numbers about if the ADU, let's say that the Brugge's hypothetically went the ADU route, and I had given a couple numbers that I believe to be accurate, but I would just like to clarify that for the record, if it to be true. If the ADU route was pursued rather than connecting the garage, is it true that they would be able to build that ADU taller than what they're actually requesting currently?
Yes. So height requirement for a detached ADU is 25 feet, and that height is actually measured to the midpoint of the highest gable. So the midpoint of our highest gable that we are showing in our proposed addition is measured at 22 feet 5.5 inches. So that is 2 foot 6.5 inches lower than what we would be permitted to do with a detached ADU. But we are proposing it to be connected. So with that, we follow principal structure setbacks and height requirements. So with that height requirement for a principal structure, it is 35 feet, which our proposed structure would then be 12 foot 6.5 inches lower than that. If you look at the existing principal structure that is there, that highest midpoint is 24 foot 6.5. So they are then again below the 25 feet there. So we are a good 3 foot 9 inches lower than the existing house is what we're proposing as well.
And as far as yard setbacks from the Woods property, the ADU permits it to be built closer than what the Brugge's are requesting via this variance in this project, correct?
Correct. So a detached ADU follows the accessory structure setbacks and height requirements, as I said. So an accessory structure is required a 3 foot side yard setback and a 3 foot rear yard setback. And our existing detached garage is at 3 foot 9 inches away from the existing or from the property line.
And with this proposed plan and variance and the plan that would ultimately be built if the variance were granted, it's not building the unit any closer to the Woods property. It would remain at that 3 foot 9 inches, right?
Correct. The addition is shown to align with the existing garage wall.
Okay.
So it would be no closer to the existing property.
So just to make sure that I accurately state this, then correct me if I'm wrong. If the ADU route were, if they decided to go that route, then they would be able to build it taller and closer to the Woods property line.
Yes.
Correct.
One other item that I think is worth mentioning or asking about rather is you submitted a very detailed letter with the application with a lot of analysis in it. And part of that analysis was that you created a shadow analysis of what this addition would create upon neighboring properties, including the Woods property, right?
Correct.
Okay. And Mr. Sturkey, I don't think I need to really, unless you have questions about it, of course, which RWA can answer. I don't think I really need to ask them much about that. Happy to, but you can find that in the application submission. It's minimal additional shade or shadow. And mind you that the worst of it would be during the winter time when there's not as much foliage on the trees. There are trees currently in place that, and RWA, correct me if I'm wrong, that limits that additional shade or shadow created by the addition, right?
Yeah, perhaps most importantly is that additional minimum amount of shadow is only during a certain time of the day. It's not all day long. It's not any different than the trees on the other side of the Woods property that cast a shadow into their yard mostly in the morning as well.
I think it's also important to note that you wouldn't have much more shade than you would if you did the detached ADU route with what we're proposing.
Because you could build it taller and closer to their property line.
Correct.
I do want to mention really quick about the height that we are proposing. The height from highest peak of the existing garage to the highest peak of the proposed addition is only 8 feet taller than the existing. And that height is limited. That was to maintain code head height for the stair to the second floor. And that is it. We did not put it any taller than that. It is really only to maintain that head height. So that was to limit the height of the building and appearance on the outside as well.
Before I ask Molly to speak, is there anything else that you would like to say, or Mr. Sturker, are there any questions that you have of RWA?
I have no questions right now.
I think that we have touched on all that I have noted.
And Mr. Sturkey, I'll just note that The application that they submitted is pretty detailed. There is a lot of information in there. If for any reason you have follow-up questions at any point in time, we're happy to answer them.
Thank you.
Thank you, Mr. Sturkey.
Molly, if you could, please, I would just like to turn this over to you to say whatever you would like to say in support of the application, but also to touch on some of the subjects that I had mentioned and obviously correct anything that I may have said.
Sure. Kevin's going to share in this with me. But first, Arlie has kindly taken her time to come here on this hearing, so I want to address her concerns first because I'm sure she has work to do. So Arlie and I have been working with the city, or trying to, between ourselves and the city, to address the water runoff issues from Windish Avenue. The Woods also get water runoff from there, and they have been able to deal with their issues in a pretty manageable way. Arlie and I are still working on that. A lot of the water that runs off Windish comes through the southwest corner of our property and washes through our backyard, and then ultimately ends up at the lowest point, which is unfortunately Arlie's basement. So one of the things that she and I have been working on is, again, getting the city involved, which we had some luck last week, they were out. But also I get some pooling in our driveway, which is a nuisance to me. And I think eventually could potentially be making its way to Arlie. So one of the things we plan on doing is extending a catch basin that we already have in place in our backyard to try to catch more of that water and keep it from going to her. As well as with this project, with the addition to the garage, I've already spoken with our landscaper. We are going to add ground cover to the hillside back there to help try to slow any additional waters down. And I fully plan on, if there's any construction issues that could lead to additional water or less grass or anything running to Arlie's backyard, I'm very aware of that, and I'm very sensitive to that, since we have put a lot of time and effort into trying to get the city to listen to us. So the last thing I want to do is make her issues any worse. So we will be very proactive, and I would hope that know that Arlie will share with me if there are any increased additional issues that maybe we aren't seeing that we can help address immediately. Arlie, do you have anything to add to that, or?
Sure, thanks. Yeah, we're not in opposition, of the project. We support it. Yeah, it's just the other stuff that happens mostly during the construction. I guess you know how it gets when contractors go through, they tear out all the ground, all the grass is going to get torn up. It's mostly those kind of things during the construction. I want to make sure the erosion protection is in place. And then in the future, I guess I do have a question. I don't have a copy of, Molly shared with me everything, but in front of me, I don't have a copy of the drawings, but I did notice on the side of the house where, that's like a above ground little kind of like swale, is that? Or is it a side, that's on the side of the house? It looks like the addition is going to cover part of that. Like, is that being, just have a question about that. It's more of a technical question. I just want to make sure things aren't worse for us during construction and after. And obviously Molly just said they're going to do the expand the catch basin, and that's great. That's wonderful. I did have that just popped up as a question though. Do you know what I'm talking about on the drawing?
We're not building it back any deeper. We're just filling in the part between our house and our garage.
So I don't think it's going to displace any water.
Yeah, if anything, I don't think that would even come into, with the flow of the water. I don't even think that would come into contact.
Can you show the drawing?
Jordan, can you pull that back up, please?
Yes, just one second. Let me share my screen here.
It does, unless what I'm looking at is not building.
So I believe that you're on this side of the property and they are building over on the east side.
Right. I'm talking about the strip see where it says concrete? That's like their patio and steps back there.
Yeah.
And then to the
here.
yeah, and then to the right of that, or is that north? I don't know which way is north, but where
North.
it's grade, is that north? And then see how it clips that drainage swale there? Is that drainage? I guess I'm just
Lori,
asking.
or I know what you're,
This-
Arlie, that's our dry creek bed. That actually takes water down to the drain. So that will actually still, we're just gonna shift that corner and water really doesn't come down at much. It's just the dry creek bed that we have along
Are
that
you-
side of our house.
Aren't you building structure right there?
I mean, it will clip it, that it will still be there. There's still,
Molly, can
will-
you put the cursor over the area they're discussing right now?
right here.
Is it here?
No, so do you see this little piece right here? This little like curved piece on the addition where the stairwell will be? That is
So
currently
just-
rocks.
I'm sorry,
just for
Molly. we can't
clarity,
see our cursors.
yeah, Jordan is the one
Oh.
operating the cursor.
Oh, so Jordan here, I can't share my screen. Jordan,
I
go
can
to the,
stop
go to
sharing.
the far right of the stairs,
Okay,
right there where that is what we're talking about right here.
okay, I'm following, sorry.
So that water would not, obviously would be blocked from coming toward you, Arlie, with the structure.
Well, you know how it goes. It finds its way, water, right? I want to make sure these things are, and it's not your job to do, but like are thought out. Like what's going to happen to that? Is it going to make something else worse? That's all.
But
Like
but
the
that's
drainage
actually
is
sloped.
changing.
The grade of the yard is sloped, so that will actually go
Towards
forward.
our house.
So
Yeah,
what are you?
the yard slopes down towards the front.
Yeah, but
And
there's
there's a massive
water
catch
that
basin
comes
down there.
careening out onto the asphalt driveway back there. So I just want to make sure that that's not going to be increased. The amount of water is going to be increased because you're building on a part of the dry creek.
It should,
Well,
no,
And the dry creek was aesthetically put in. Now, we did that just for make the side yard between us and the woods look as aesthetically pleasing as possible. It really doesn't have there was no utility for it there before. And we created it to actually look nice, but then also help to try and take the water down to the front corner of our yard where there is a big sewer drain.
Right, but how does the water that comes out onto your driveway, where is that coming from?
Comes from the back corner, comes from Windish.
it comes
Okay.
from,
There's no increase in water from this coming onto the asphalt driveway.
Yeah, I would get that. I'm talking about the creek bed area.
Right.
That area would not either. What now gets rain and goes over that way will go on the roof and go into the gutter and the downspout.
And then travel down that dry creek bed.
Okay, I've been out there. I just want to make sure that part's addressed. That's all.
I mean,
We will address it.
we will continue to address it, I promise.
Okay, anything else from the Brugge's?
Molly, is
At this
there
point?
more that you would like to add with respect to anything that I said?
Mr. Sturkey, can I just ask, do we get a chance? I can't remember the agenda. Do we get one last chance at the very end to say anything, or is this our only chance?
You'll get an opportunity at rebuttal to respond to any of the arguments that are made in opposition, and then you'll get an opportunity for closing statements, which will probably be Mr. Trout.
Yeah, I
So
think
if there is something you'd like to
we'll
say,
save
you
our
should
comments
say
for
it
the
now.
very end.
Okay.
Yeah, I think everybody said everything we
Yeah.
can say.
We'll
Okay.
keep this going. Thank you.
All right. Okay, Mr. Trout, did you have any other witnesses you wanted to call?
At this point in time, no, Mr. Sturkey.
Okay. All right, great. Mr. Burley, do you have any cross-examination for anyone that testified for the applicant?
I have a few brief questions, Mr. Sturkey. I'm not looking to take up any more time than necessary or make this more adversarial than necessary. You've heard a lot of this last year when we were all in a Zoom meeting for really the same matter. Just as a point of order, if there needs to be an appeal, would that proceeding be in the record by reference? Or do we need to go through all of that again?
So the decision, I believe, has been submitted as a part of the record, but I don't believe that any transcript, recording, or testimony is a part of the record as of right now, that unless it's already been testified to.
Okay.
So
Well,
I think you need to create a record if you're worried about an appeal.
well, then I just have a few brief questions then. First directed to the brood use, please. When did you tear down your prior garage? What year?
2016.
And if your architects could share the site plan on the screen, could you indicate for the examiner where your prior garage was, please?
It was where the current stairs and like fire pit area are. Yes, in that
Thank you.
region
Thank you. And when did you construct your current garage?
in 2016.
Thank you. I believe that is all I have for the Broogies at this time. For RWA architects, please. What is the square footage of the current Broogie house, the primary structure?
Just 1 second, please. I don't believe that I have the square footage of the principal structure. I do have the square footage of the existing detached garage and the proposed addition.
Do you know the total square footage of what this principal structure would be if your variance was approved?
I don't have that on hand. I would have to calculate that. I apologize.
I don't believe there's a limit on what square footage that someone can build there.
I know that for a detached garage, there's a limit for 15% of your site. I know that we are well below that. If you combine the two parcels of the property, which they plan to do, they would have 18,000 square foot property. And 15% of that is 2,700 feet, square feet, and we are below or around 800 for that addition. So
Thank you for that. Thank you
I'm
for
not
that.
sure about the actual principal structure.
Okay, so what I'm hearing is that you don't know the total square footage of the existing structure or what the total square footage would be if this project is approved. Is that correct?
I know that the existing house plus the addition would be 100 feet, 105 feet depth. I do not know the total square footage.
Okay.
Would you
Thank
like to calculate that?
I could calculate.
Yes, that would be helpful if you could do that. Thank you. What is the depth of the proposed connector structure? I'm asking about the current, I'd say front elevation of the garage as opposed to where it will be closer to the street if this application is.
The proposed addition will only be 6 feet closer to the street than the existing garages.
So the connector structure is 6 feet in depth.
It is 6 feet further from the street than what is proposed.
And I heard a suggestion that possibly these lots might be consolidated. What is the total width of these two lots?
I don't have that calculation on hand. I just have square footage.
I looked on pages earlier today. It looked to be around 98 feet. Does that sound about right to you?
I would have
With
to
survey.
I would have to check the survey. Let me see if I can pull that up real quick and see if they have it noted.
Okay, thank you.
Mhm.
While you're looking into those things, just my final question for the architects is, what, if any, substantive changes did you make to the site plan compared to the 2023 submission?
No changes have been made to the site plan prior to the previous decision.
Thank you. All right, well, I can come back to you on those.
It's roughly 96 feet and say 9 inches.
For the width of the property, is that
Yeah,
what you're saying?
yes, the width.
I appreciate it. Thank you very much. And if you do find the square footage for these structures, we would appreciate knowing that as well. But Mr. Tamer, that's all the cross-examination I had at this time.
Sorry, folks. My internet is a little unstable right now. I did hear everything, unless something was mentioned in the last 10 seconds. But I heard the last question from Mr. Burley. Mr. Burley, if you have no more cross-examination, we're going to move to public comment. Okay. Let's see. I think that we have John Blatt and Gina Blatt. So whichever one of you would like to go first, the floor is yours.
I'll go first because I got to get going here. So I just want to say I appreciate that the Bruggies are investing in the neighborhood. It's I think it's aesthetically more pleasing for the attachment for the house than rather to have a separate building. For the neighborhood, it just continues the investment that we see a lot of our other neighbors making in the neighborhood. A lot of the homes are older, and it just, you have no choice but to bring it up to today's standards. If they wanted to find another house in the neighborhood, it's hard to find a house in our neighborhood to meet today's needs. So these are just changes that that unfortunately people have to make. And I think we're all, if you look all over our neighborhood, there's all sorts of different variances. Some houses are closer to the streets, some are further, lots are bigger, some are smaller. So I think it does fit with the spirit of our neighborhood. So I'm okay with it, and I'm glad they're doing it. That's it.
Okay. Thank you. Ms. Blatt, Gina Blatt, did you want to say anything?
Yes, yeah, I agree with everything John said, but I'll just add that I am gonna see the new structure from our west facing windows pretty well, and I'm very confident that it will look great like the rest of their house does. And Molly takes meticulous care of her lawn. Whenever I walk by, it's amazing. So I really don't have any doubt that it's gonna look good.
Okay, great. Thank you both. Mr. Burley, did you have any questions for John Blatt or Gina Blatt?
I do not. Thank you.
Mr. Trout, did you have any questions for them?
I do not. Thank you.
Okay. John, I know you mentioned you needed to go. Anyone that was here for public comment is welcome to leave at any time after they've made their statement, but also welcome to stay if you would like. Okay. Going to move on to a presentation by Mr. Burley. Mr. Burley, this is your opportunity to present witnesses and make arguments.
Thank you, Mr. Examiner. I would like to start this whole presentation by emphasizing that, as before, the Woods have no ill will here toward the Bruggies. The issue here is not whether the Bruggies are good people. This is not a personal issue. The Woods had the Bruggies kids over for a dog's birthday party last month. This is simply about the impact of the proposed design on the Woods' use and enjoyment of their backyard. And all of this was it's really already been discussed, Mr. Examiner. This is the exact same application as was submitted last year. You heard from the architects just now, they made not one change to the site.
So, Mr. Burley, I hate, sorry to interrupt, but what's your response then to Mr. Trout's argument that, you know, the city has made changes to the zoning code to try to make these types of projects easier to build?
I think all the discussion of the ADU ordinance is a red herring, Mr. Examiner, because the applicant has not applied for an ADU. That is not what is being requested here. If you were to compare the actual relief that's being requested from the 2023 application to the 2024 application, it is verbatim. It is the exact same relief that you are reviewing. So you're reviewing this under the same substantive law, which is the variance standard. And you need to review the public interest requirements and the practical difficulties test in order to grant them the relief that they are requesting. You have already determined each and every one of those issues. What Mr. Trout has suggested is that the ADU law is some sort of a change in law that changes how you evaluate the overall request here, but that's not accurate. You are still reviewing the same substantive law. The Ohio Supreme Court has ruled on this multiple times. If you are submitting the exact same zoning application, seeking the exact same relief, that's barred. That's barred by claim preclusion. It would be the same as if you brought the same lawsuit based on the same claim that had already been dismissed. It's the same concept, Mr. Examiner. And they really haven't made any argument that their application is functionally different. Again, the site plan is identical, not one change. And the substantive law that they're applying under is also exactly the same. If they wanted to build an accessory dwelling unit by right, they could do that. We wouldn't be in this hearing. The issue is that the ADU law actually does not permit their project. They still need the exact same variance. That's why we're here. So I think the ADU law is really a red herring. There's been this suggestion that, well, we could build higher, we could build closer. I'm not really sure that's relevant, Mr. Examiner. For one thing, I do not follow the argument that they could build closer. If you look at section 142106 of the zoning code, the way I read it, Mr. Examiner, is that ADUs still have to comply with setback restrictions applicable to the underlying zoning district.
So I'm looking at F2, detached accessory dwelling units are subject to the side and rear yard setback requirements for accessory residential structures in the applicable zoning district. So I think their argument is that the accessory residential structure side setbacks would be, I think, 3 feet. I don't know if that's right. Not looking at the actual chart here.
That was what we were saying.
In any event, Mr. Examiner, the bottom line is that that's not what they have applied for here. They are free to do so, and the Woods understand that if the Brugge's did that the Woods wouldn't have any say in it. That the law has changed, but it has not changed with respect to the application you have in front of you right now. I would suggest to you, Mr. Examiner, that you really look at the Grava v. Parkman case that we've cited in our statement in opposition, because it is on point. And the Ohio Supreme Court said that when you are trying to build the exact same building on the same tract of land under the same mechanism for zoning relief, that's barred by claim preclusion. And that is exactly what is happening here. Even if you did not think this was barred by claim preclusion, Mr. Examiner, it would still be barred by issue preclusion. We're arguing about all of the exact same issues that were discussed in 2023. There's been no change in facts. The Woods are still opposed to the additional massing of a principal structure within 4 feet of their side property line in a way that's going to significantly impair their use and enjoyment of their backyard. The application is exactly the same. I'm not sure what factual difference really could remain. There was, Mr. Trout did not bring this up in his opening statement, but the letter that was submitted also suggested that there was a change in law from the Connected Communities update, but that's not relevant here either. The underlying zoning for this property remains the same. It still remains zoned as SF10. There's no overlay for neighborhood business, middle housing, transportation corridor. Still the exact same zoning, still the exact same relief that is being applied for. I'm not sure I would even call this a factual change, but there has been some suggestion that the examiner should consider the variance that was granted for 3440 Principio. And the case for that is ZH20240001. That is a fundamentally different set of facts, Your Honor. I'm sorry, not Your Honor, Mr. Examiner, force Pat. For one thing, the zoning was different. That's an SF6 district, not SF10. Second, the actual construction that was being proposed is nothing like what's happening in this case. At 3440 Principio, the garage and the principal structure, both in footprint and in height, remained exactly the same. The connector was a small wooden pergola that was constructed over the top of an existing brick walkway. And most importantly, there was no objection from anyone in the neighborhood because foreseeably that doesn't cause any adverse impacts to anyone if someone puts a pergola between a garage and a principal structure. We actually appeared at that hearing and argued that that shouldn't require a variance at all because those remain separate structures, but that's an interpretation for a different day. So that's really a fundamentally different set of facts that is simply inapplicable to what happened here. 3315 East Side Avenue, that was also mentioned in the letter in support of this application. That's also a fundamentally different set of facts. That was a 33-foot wide lot, Mr. Examiner. Quite literally the only place that those property owners could expand was backwards. In this case, you have a near 100-foot wide lot. And the Brugge's have made an intentional decision to build this garage within 4 feet of my client's property. And they can do that to a certain extent by right, but I don't think it is fair or accurate to say that this causes no impact to the Woods when they are seeking to go above and beyond what the zoning code permits by right. And really, you've addressed this entire set of circumstances before in your 2023 decision. You noted at that time that the condition giving rise to the need for relief was created by the Brugge's. They intentionally tore down their prior garage and they chose to construct this garage in its present location. And they knew at that time, Mr. Examiner, that if they did that, they would not be permitted to connect them. We, in our 2023 statement in opposition, we provided a snapshot from the Easy Track. This is a public record. The permit at the time for the new garage had a comment from zoning. And it specifically said, it is acceptable to consider the garage as detached because the wall between the house addition and the garage is only a few feet high. If the connection between the house addition and the garage should be increased in any way, the decision will be reconsidered. Essentially, the zoning department put the Rubies on notice back then. If you ever want to connect this, that is not permitted by right. They had full knowledge of the prohibition in the zoning code, and they chose to put this structure there anyway. So there's no practical difficulty when the property owner itself creates the situation for which it's seeking relief. This has already been decided directly in your 2023 decision. You concluded in your 2023 decision the condition giving rise to the request for the variance is the size of the east side setback of the existing garage, which was constructed by the owner in 2016. So there's no practical difficulty here, Your Honor. It's the exact same set of facts. They created this themselves, and that's not something that a variance is designed to provide relief from. But let's get it. The Rubies are a growing family. That's wonderful. That's a great thing. But that is not a unique situation. I believe those are the words that Mr. Trout used, a unique situation. A growing family is a commonplace set of facts that affects countless citizens within the city of Cincinnati. And you specifically said in your 2023 decision, while the owner's desire to expand the size of the home to accommodate a growing family is generally reasonable, there are limitations to the expansion, size, and scale of structures on any property. The SF10 zoning district is one of the least dense zoning districts in the code, and allowing a side setback of a principal structure to be reduced from 15 feet to 3 feet 9 inches is significant and substantial. So I don't know how many times I could say it, Mr. Examiner. Same application, same relief, same standards should be the same result. I do appreciate Mr. Munzel's close analysis of the similar properties that were provided in the application. Same as last time, Mr. Examiner, I think if you will look at that closely, you will find that there is not one example of a variance being granted for anything close to as small a setback as what's being proposed here. They're either at least 2 times greater a setback, or it's a non-conforming structure or something that was probably built illegally. There is not one on-point case that the applicants have identified to show that there's some sort of precedent that would justify bringing a principal structure within 4 feet of of my client's property. I do not believe that the mere addition of additional letters in support is a change of facts. This is not a referendum on whether the 2023 decision was decided correctly. The neighborhood does not get a vote as to whether you got that decision right. Your reasoning still applies because there's been no change of law, no change of material facts. And specifically, one of the things that you noted was not related to any of the folks that provided letters in support. It was specific to the woods. You said the height, scale, and reduced setback of the garage project are likely to have adverse visual impacts, as well as impacts on light, air, privacy, and noise for the property owners at 3459 Principio Ave. These are exactly the type of adverse impacts the setback requirements are intended to avoid. And the applicant failed to demonstrate how these impacts would be mitigated. So I don't believe the letters in support provide any basis for deviating from the effect of last year's decision either. See if there's anything else that I wanted to address here. Well, just the last thing, Mr. Examiner, was there was a suggestion again that this garage addition connector project would not necessarily be a good investment for the Bruggies. They're looking simply to enjoy their property, not necessarily increase its value. That's fine. That's a completely reasonable choice to make, but it doesn't come anywhere close for purposes of the Duncan factors of suggesting that they're not getting a reasonable return on their property. They have what I would say is a beautiful house and a very attractive garage already with a fairly nice back landscaped area. They are getting a full and reasonable enjoyment of their property right now under the terms that the zoning code actually permits. So there's really not any practical difficulties specific to them that they didn't create that would apply here to justify relief from the zoning code. So for all of those reasons, Your Honor, Mr. Examiner, and those contained in our letter, this is really a foregone conclusion that you, the zoning hearing examiner, and the parties to this case are all bound by that prior decision. It's the exact same application, exact same standards, exact same set of facts. It's a foregone conclusion, and for that reason, we would ask that you either deny it, dismiss the application because it's simply a resubmission, and that's barred, or deny it because all the issues have already been decided. Tony and Lori, did you all want to add anything about how this would impact your use and enjoyment of your property? How you use your yard now, what this would look like to you if you had to sit out there?
Well, it's just it's an extraordinarily big project that we feel aesthetically doesn't fit within the neighborhood. It affects us really. We're the only people it affects. You know.
And if it would have been 15 foot in or whatever originally, we would not have objected. We didn't object when they built the garage.
Well, we wouldn't have it. They were perfectly within their rights to do that. And they're perfectly within their rights to build an ADU. If that's the way they want to go, they can do that. But we also, I will say this, we did not have any input on the city creating this ADU. I understand the concept behind it. So housing shortage. To me, this is the ADU is being used like a lot of the changes that happened in the zonings, you know, the LEED situation with property taxes. This was for Kennedy Heights, Pleasant Ridge, North Avondale, or, you know, pick a, we don't know why, you know, it's being used. The ADU really shouldn't be, my personal opinion, shouldn't be in Mount Lookout Hyde Park. And I know that's not relevant to what we're talking about here.
But to be clear, you understand if they built something by right under the code, you wouldn't have a say.
Correct, we understand.
And so your specific objection is the 6-foot extension of the garage.
Well,
that is not permitted by.
Right, and it's an extraordinary thing. From the street, you know, where the house starts, the way the plan is submitted. I mean, I don't know what the total footage is, but it's extraordinary. I mean, it's just a solid wall of construction, you know, all the way back to the end of I guess to the end of the garage.
We do enjoy our backyard. And this, if we sold, would reduce. We feel it would reduce the value of our yard because that's why we bought the house.
You have anything else you want to add?
Well, I did. If you look at the map, like Tony said, we're the only ones affected. Arlie, it has a fence, like a 6-foot fence, a patch of grass and a driveway. It's not even abutting up against her property. And so we're the only ones it affects.
Mr. Examiner, that's
I'm sorry, not right now, Ms. Sherman.
Okay.
Mr.
Sorry,
Examiner,
JP, go ahead.
I think that's really worth noting is there's a lot of emphasis on people much farther away that don't have a problem with this project. And that's fine, but they're really not the ones affected. What's important to note is the folks immediately next door who are going to be closest to this and have to look at it every day, who are going to have the shade coming in, the visual impacts, the additional noise that will inevitably come from the use of the structure. They are not okay with this, Mr. Examiner. And you really gave that the appropriate amount of weight in your prior decision. And that's also what separates this from the other cases where there was not any community opposition. That again, there hasn't been one example given of a contested zoning application where a variance was granted for anything anywhere near as close to a side yard property line as what is being requested here. So certainly you should give the map that the applicant has created and the statements in opposition whatever weight you feel is appropriate. But I would just ask you to keep in mind that most of those folks are not really going to be experiencing the full effects of what is being proposed here today. That's going to fall on Mr. and Mrs. Woods right here. And their position has not changed from 2023 when you already decided this.
I would say one other small thing. JP was not involved directly in the meeting having to do with, I can't remember the name of the address, but the
3440.
3440.
Yep.
It was a gentleman by name of Quinn Marker. And we asked you, Mr. Examiner, Quinn did, to because we had no opposition to to their project at all. We thought it was completely normal and understandable. But we asked you to put in your opinion that this should not, pergola should not be used as a, what's the term? Precedent. Yeah, just wanted to point that out.
And if you go back to that decision, Mr. Examiner, you did include such language. You were very careful to note that this is a very fact-specific inquiry based on the specific proposal at issue and the impacts to neighboring property owners for that project. And it should not be construed as some sort of open invitation for anyone to connect their garage to
house.
Sure, sure. Yeah, I remember that. I don't think the situation is analogous to this one, but I would like to ask a couple quick questions here of the Woods or Mr. Burley, and maybe Mr. Menzel too. If Wes, you're with me here. Can everyone see my screen? I'm sorry.
Yes.
Yes.
Okay, great. Thanks. So Wes, are you with me here?
Yes.
Wes Menzel. Okay.
Yeah.
This is the green superimposed over the existing, which is white, correct?
Correct.
Okay, thank you, Jordan. And so all of this portion here, is this the connector or to what will be the green?
No, sorry, that is their existing mudroom and covered porch. The connector piece is the portion of the green
Down here?
that reaches the ground there. Yes, where you're pointing.
This piece? Okay,
Yes.
got it.
And to be clear, we're just asking for 1 foot there. If we
Right.
built it as an ADU, there would just be 1 less foot of that connector. So all we're asking for is for 1 foot to make it a continuous structure.
Well, so that was going to be my question for Wes, and from the planning department. If so, this space is going to connect to this, right?
Correct.
Yes.
The
Yeah.
proposal is to connect the principal structure here to this new proposed garage structure, accessory structure via the mudroom, correct? And add this additional space here to accomplish that. Is that right?
Yes.
To Jordan? Okay. So if this space here were removed from our project, a physical connection, this structure would still be able to be built, and presumably Wes, slightly taller. Is that correct?
Your voice was cutting out at the beginning of your question,
I'm sorry.
about
So
15 seconds ago, but yeah.
okay, sorry about that, guys. So my question was, if this portion here did not connect to the mudroom portion, right, or there was a greater a distance of 1 foot or greater, the applicants could build a second floor on top of this garage that is 3 feet higher than their proposal now. Is that correct? To Wes?
If it's an ADU,
If they followed it as an ADU and followed all of those restrictions, is that right?
yes.
And ADUs can be used for relatives?
I don't think there's any
Wes?
restrictions on there are no restrictions on who uses it.
Yeah.
Unless you,
If I
Sorry,
may,
go ahead. Mike, give me 1 sec. Mike, give me 1 sec.
Sure.
Wes, what were you have something to finish there?
no, I think the statement, there's no restrictions on who uses it relative to, to relatives or friends, or there's no restrictions that I'm aware of.
Okay. And so, going back then, to the Woods, and this is sort of where my thinking is right now. I think Mr. Burley has made some very good points from a legal perspective. But what's challenging about this is the practical perspective. Is that connection really what the issue is here? Or is it that they can build something that height, period? And knowing that it is possible for them to just create that 1 foot space, is that really a better outcome than keeping it lower and making that connection of 1 foot for you? That's my question to the Woods, is Is that really a better outcome?
I appreciate the question, Mr. Examiner. Practically speaking, my clients understand that the Brugge's could pursue some version of this project by right. They understand that. They are not willing to give their approval to any administrative zoning relief that increases the amount of massing of the principal structure along their property line.
Got it.
And while the practical considerations are certainly important to think about, legally, Mr. Examiner, this is still the same application, same set of facts, because what is triggering the need for the variance is the exact same. It's that connector. If they weren't proposing the connector, we wouldn't be here. All the talk about the ADU is, I mean, it's helpful context at most, but it is not legally relevant to what you are deciding right now, which is whether that connector justifies variance.
Yeah, and you may be right about that from a legal standpoint, JP. But from a practical standpoint, you know, that was more how my question was designed. But I appreciate your answer, and I'll accept that. You know, we can move forward. Mr. Trout, if you do have any questions for the Woods,
I do, yes.
Now would be your opportunity. The floor is
Thank
yours.
you. Since this was the last question to ask, I do want to just follow up on that. Mr. and Mrs. Woods, whoever wants to answer, it doesn't matter to me. What is it about the connection that you take issue with? Not acknowledging in what you've already done, acknowledging and your attorney has done, that they could build this project with a 1 foot gap between the building and the residence. What is it specifically about that 1 foot connection that you take issue with?
First of all, this is the first time I've heard about 1 foot. I mean, I'm not, you know, I knew that it could do big build, big higher, and whatever. If they want to build their ADU, they can do that. We just feel that when somebody, you know, we feel like we're being bullied, honestly. And that's the truth.
And we don't like this house starts, I mean, how far is it? What's the distance in footage from the front porch all the way to the back of the garage? It's like an apartment building. It's nonstop. And it only affects us because everybody else has a fence or 2 houses between them. And I'll say the neighbors right next door to you did not approve, did not write a letter.
We chose not to bother, you know, a number of the neighbors about this. It just seems like it's, you know, we're the only one it affects. Didn't really make much sense to talk to some of the other people and try to get them to write letters. You know, it didn't seem to make much sense for us. And we have a lot of people who, you know, who volunteer and actually wanted to write letters, but, you know, we didn't feel like it was, we didn't want to get them involved, honestly.
Okay. Mr. Trout, do you have additional questions?
I do. And there's a couple of things they said that I want to follow up on, but I want to make sure that I understand the answer to my question, which is what exactly is it that you take issue with of the 1 foot connection? And if I heard Miss Woods correctly, and Miss Woods, please correct me if I'm wrong, the only reason that you two elaborated was that it is a connection and makes the house longer. Is that right?
It's starting to look like an apartment building. What is the distance? Tell me, from the front porch to the back of the garage.
I would just like to have my question answered.
And then my other comment would be, did the Brookies know when they built in 2016? They knew that this was going to be an issue. They could have, in 2016, put the garage 10, 15 feet away from us. Even if it was 10 feet, I don't think we'd be complaining.
Yeah, that's exactly right.
Is it correct of me to say then that the only issue that you take with the 1 foot gap versus connecting it is that you believe it'll appear like an apartment complex?
The appearance is negative. Do I want the value of my home reduced? No. We have lovely neighbors in our neighborhood. And everybody that signed on saying they will grow this, you know, they're just nice people and they'll say, yes, if you want that, we'll give that to you. But it affects me because I'm in my yard. And I don't want a continuous unit. And I'll say it again. I don't like that they built so close, knowing that this was what they were going to do.
You acknowledge and know, at least from this proceeding, that they can actually build the ADU closer to your property line, right?
Oh, I think I did hear that. Yeah, thank you.
I'm sorry?
Thank you. Yes, I did hear that.
And you acknowledge and understand that, right?
I think I do.
Yeah, I think we do.
Okay. And you acknowledge and understand that they can build it taller than what they're proposing.
Yes.
Okay. So again, and I'm sorry to come back to this, but I want to make sure I understand. So now the two reasons with the connection alone that you have is that the appearance is negative. You said that it looks like an apartment complex and that the value of your property will be reduced. Is that right? Is there any other reason?
Yeah, I think this has been asked and answered. I think those are the reasons she stated.
I just want to make sure that's it.
If there's anything else from the woods, you can answer the question. Any other reasons why?
No.
Okay.
All right. Let's talk about the value for a second. On what do you base your statement that the value of your property will be impacted?
Yeah, I'd like to answer that. I have a number of friends who are real estate appraisers. And I said, I described this entire scenario to them. And they said, I said, can I hire you guys to make a case that we will be hurt by this structure? The value of the home will be hurt by this structure. And they said, this is what you would have to do. You would have to find a house in the neighborhood that had a similar structure built. And you would have to be able to show that that project affected the value of the home, next door. It's literally impossible to be done. It cannot be done.
So just to be clear, you've not performed any.
Can I make a point on that?
Yep.
Just,
No.
I just want to say something.
No.
Oh, okay.
No. Sorry. You'll have an opportunity on rebuttal to address anything that's been said. Mr. Trout.
you had said that one of the other issues with the variance request is that noise will come from the use of the structure. Now, I mean, I'll acknowledge, I think that use of anything creates some noise, but do you have any support or information on which you base that statement that the granting of the variance of being able to connect this building to the home will increase noise?
Oh, we don't care.
I'm sorry?
We don't care about the noise.
Okay.
I mean, the noise coming from the structure or being built.
I'm just saying, one of you had said that there will be noise that will come from use of the structure.
Oh,
No, that was,
we're okay with that.
that's fine, we don't care.
Okay. Can you explain to me how you believe that you are the only ones affected by this variance?
Pull up the map. Of the neighborhood. Pull up the map of the neighborhood.
So just to be clear, then it is your position that nobody else in the neighborhood, no other neighbors besides yourself will be impacted in any way by the grant of this variance?
Mr. Examiner, I'll just object. I don't believe they said that. He's trying to introduce things that they didn't say.
No, actually, I wrote it down. They said, we are the only ones it affects.
Well,
They
let's
said that
start.
multiple times.
I think they can answer the question whether or not that's what they believe.
Can you put the map up of the neighborhood?
Jordan, would you mind pulling up the demonstrative of the map? That was you last time.
Yes, I can do that.
Okay. CR Red House.
Yes, right next.
And well, maybe, so in general, we're the closest. Then pull up the map with the barn, the garage on it.
1 second, please.
There. Okay. Now see our house and see how our yard is. You see how close we are to the garage? Yes, perfect. Now look at the far left of the screen. There's 3 plots of land. Look how far they are. So we're like 3 inches from the garage, and I can't see the numbers. How far is Arlie from the garage? Do I get an answer?
Well, is there anything else that you want to say?
How far is Arlie from the garage? How many feet is that?
So, Miss Wood, not really your time to be asking questions. If I could attempt to cut through this, I think his question is, are you saying that you're the most directly impacted, or you're the only neighbor impacted at all?
Both.
Okay, thank you, Mr. Trout.
I'll leave it at that. I don't have any further questions for them, for the Woods.
Okay, I didn't mean to cut your cross-examination short, Mr. Trout.
No, totally fine.
So please, if you had anything else, the floor is yours. Okay. All right. So I think now we're going, before rebuttal, we will hear from Wes Munzel if he has any testimony that he would like to add in addition to his staff report. And just for the record, for the attorneys, government officials are not subject to cross-examination. So. Wes?
Mr. Examiner, just before moving forward, if I'm looking to rehabilitate the woods, would I do that now or during the flood?
Yeah, so there wasn't really a redirect on cross-examination earlier. So I'm not sure that we're going to have a redirect on that one.
Okay, thank you.
Sure. But of course you'll have an opportunity in closing arguments to make points. Wes?
Good afternoon. I do not have any additional comments beyond my staff report.
Okay. Thank you. Mr. Trout, I think just based on timing here for rebuttal, I am going to put a time restriction of 15 minutes. So if we could keep it under that or close to that, I think that'd be good before we move into closing.
Sure, that should be
Sure.
Plenty of time. And just to be clear, Mr. Sturkey, I can ask Kevin a question for rebuttal, right?
Yeah. So any of the witnesses that you ask questions of before, you can bring it back up, but the scope should be sort of limited to responding to arguments that you heard or testimony that you heard from the Woods and Mr. Burley.
Of course. Mr. Berge, Kevin. Earlier,
Yes.
I had asked some questions of the Woods, and you were wanting to speak up to address one of those issues. I believe it had to do with the connection and how it may negatively impact them. What was it that you were going to say?
Well, it was actually on the value equation. So we did our last edition in 2016. And if you go to the auditor's site on 2015, the Woods property was assessed at 507,000, and currently it's assessed at 620,000. So it's like a 22% rise over that that period of time. So I guess I was just kind of making the point that, you know, we invested in the neighborhood, we invested in our property for sure, certain, but I'm just not sure how there was a detraction of value. So that was the only point I was going to make, Taylor. Just adding the auditor's site factual information to that comment.
Couple questions for Jordan and Mike.
Yes, sir.
How is it that the 3440 Principio project is analogous or related to this analysis?
Yes. How it's related is that they were requesting well, they are in a different zoning district. They're in SF6, as was stated by JP Burley. But under that zoning district, they do have a 7-foot side yard setback and a 35-foot rear yard setback. Their existing detached garage was conforming to an accessory structure at 3 foot away from the side yard and 3 foot away from the rear yard. So they were requesting a 4-foot side yard setback variance and a 32-foot rear yard setback variance. So with that connection, I think that creates a substantial property right to the Brugge's.
Just to dig in on that a little bit, were they requesting an increase in the height or the size of the accessory structure?
They were not.
Were they requesting an enclosed space with walls and structural elements to connect the two spaces?
They were not.
So they weren't analogous in that way then?
No.
If I may, in my 35 years of working in the city of Cincinnati and zoning regulations, the connecting, it isn't defined by what zone you're in, what R6, R10, it doesn't do that. It just says it's connected, and by them connecting their property, it's 3440, they created basically non-conforming conditions that they needed a variance for. In other words, they were fine the way they were. They connected it, and now they needed a variance by that connection. And I think that's as simple as what we're doing here, is we're asking to connect these two structures here. It doesn't matter whether we're in F12 or F6 or whatever, or R6 or R12 or R10, whatever it is. We're just asking about the connection. And the connection comes down to, is there a big difference between, in my mind anyway, architecturally, a 1 foot gap or it's connected? And if you can build it bigger, taller, more square footage and leave it 1 foot off, and the city says that's okay, and we're just asking, can we just connect the 1 foot here? It doesn't substantially change anything in my mind architecturally. I mean, the apartment analogy, I don't even get that at all. But in any case, I don't see the difference when you say that's a totally different aspect on 3440 than what we have. They connected that. They were given approval to connect it and turned a conforming accessory structure into a non-conforming structure, and it was approved.
I think it is also important to note that the hearing was put on public record. So I did, although I was not attending that, I did watch the hearing. And I think it's important to note that the people, the property owners of that site were, it was made clear to the Woods that were in that hearing that with the approval of that variance, it would be in their property right then with the connection and then being a part of the principal structure, that they would then later be able to build on top of that higher to the principal structure height requirement. Am I mistaken in saying that?
Is that a question for me?
You or Wes?
Wes, do you know the answer to that?
I'm sorry, can you repeat the question?
I think she was asking if once the connection was made and approved, could they increase the height of the accessory structure since it was considered part of the principal structure at that point?
No, I think they need to get
I don't want to get,
variance.
okay. I don't want to get too far afield here with hypotheticals.
I'm sorry.
I understand your argument, and Mr. Trout, I didn't mean to hijack your now
No,
rebuttal.
totally fine.
I'm sorry, but
No, jump in
I
when-
understand the argument you guys are making about the analogy there, and so we can leave it at that.
Let me ask one just follow-up question to make sure that we're understanding here. What is RWA, just for clarity purposes, what is it exactly the variance request that we're asking for here?
We are asking for a dimensional variance of 15-foot side yard setback.
So we're asking for a variance from the setback code, the requirement for the setback, right? Yes?
For principal structure, yes.
Okay. And that is exactly the same variance request that 3440 made.
Theirs was slightly different because ours has the 5-foot additional with the additional depth to the house with the connection.
So different analysis, I suppose, or different setback requirements. However, their request was for a variance to the setback requirement.
Yes.
Yes.
Correct.
Okay. Had nothing to do with building on top of it. And ours, we're not seeking a variance to build on top because it would comply with all zoning code.
The
Yes.
height, yes.
That's really all the questions that I have. I do have other things that I would like to say, but Mr. Sturkey, I can save that for closing.
Okay, great. JP, you'll start us off here with your closing, and then the applicant will have the last word. Would the two of you be willing to agree to time limit on closing?
That's fine by me.
Mr. Sturkey, I may have misunderstood your instructions at the beginning, but I was under the impression that I would have the chance to ask additional questions of the Woods before my closing.
I think that's right. And oh, wait, I'm sorry, of the Woods?
Well, I believe you said that Mr. Trout would have a rebuttal, and if I heard you correctly, that I would then have a rebuttal.
I'm sorry.
Well, I guess I need to lodge an objection for the record then that I would like to ask questions to the Woods about property value and visual effects.
Yeah, I'm sorry. There's just not anything in the rules. I apologize if for any reason I misspoke, and that will be a part of the record. But you know, the rules are clear that the applicant that has the burden of proof is the only one that has an opportunity for rebuttal.
Okay. And may I ask cross-examination questions of his rebuttal witnesses?
Yes.
Okay. Mr. Brugge, are you a certified appraiser?
No, I'm not.
Do you have any training in real estate valuation?
Nothing formal, no.
And do you live at 3459 Principio?
No, I do not.
Mr. Examiner, I would ask that his testimony regarding property values be stricken from the record as he's not competent to testify to that issue.
I would just respond, he's literally testifying about the record, the public records of the auditor evaluation. I mean, he didn't give an opinion of anything other than factual statements from the auditor's records.
Yeah, I'm going to overrule the objection, or I'm going to deny the request to strike the testimony.
That's all I have. Thank you, Mr. Examiner. And I'm
Sure.
happy to start closing if you'd like.
Yeah, can we
with-
agree that 10 minutes would be enough, or would you guys like some more time?
10 minutes should be fine for me.
Yeah, I agree.
Mr. Trout, is that okay? All right.
Totally fine.
Well,
Thank you.
Well, it's 5 o'clock now. So, Mr. Burley, floor is yours.
Mr. Examiner, thank you so much for your time and attention today. We've heard a lot of testimony about what the Brugge's aspirations are for their property and what they may or may not do if this application is denied. But legally speaking, you are here to determine a very particular standard in the zoning code, namely whether they qualify for a side yard setback variance from 15 feet to 3 foot 9 inches. I think it's very telling that Mr. Trout said just now, they're not applying for a height variance. That's not at issue. They're applying for a side yard setback variance. And what you will find if you look at the application form from 2023, if you look at the application materials from 2023, if you look at the staff report from 2023, if you look at your decision from 2023, this is the exact same case. Same zoning district, same property, exact same set of plans, exact same zoning relief that is being requested with no material change in facts whatsoever. This is a foregone conclusion already. You are precluded from finding otherwise as a matter of Ohio law. And again, I would strongly urge you to look at the Grotto v. Parkman Township case that we cited in our statement in opposition. So the reason that this is all really the same case is not anything has changed. They're proposing the same thing, and our reasons for opposition remain the same. So if you were to dig into the actual standards that you need to address in your written decision, you need to look at the public interest standards, and you need to look at the specific standards for an area variance. And you will find, if you examine the record in this case compared to your decision in 2023, the result is exactly the same. This project is still not compatible with the surrounding development. They have still not identified any public benefit. This solely benefits them. And it still poses adverse impacts to the woods in terms of visual impacts and property value impacts. I think if you read their testimony generously, they argued that they will suffer a loss in property values as a result of this project. They are competent to testify to that as property owners. There is no evidence to the contrary in the record. And you already decided that last year in your 2023 decision. So this is not in the public interest. Nothing has changed that would justify a different result. And on these specific variance standards, Mr. Examiner, this situation is still a result of the Brugge's decision to build their garage in its present location in 2016. They did so knowingly with full understanding of what the zoning code did and did not permit. There is still no on-point example of a similar project being approved by a variance in a contested setting this close to a side yard property. The owners are still making a reasonable, economically viable use of their property. And this is still a very substantial reduction in the side yard setback from 15 feet to less than 4 feet. That's a 75% reduction. You correctly found in 2023 that that's substantial. Nothing has changed. The adverse impacts are the same. The woods, I think understandably, do not want a continuous massing of one structure all the way along their property. That is a reasonable position for them to take, especially when you compare the size of their structure, their principal residence, to that on the Brugge site. That goes back to the issue of compatibility, Mr. Examiner. The overall scale and massing that is being proposed here is simply not in character with surrounding development. And I just want to push back on this specter that keeps getting raised of what they allegedly could build by right. That is not before you. They have not proposed an accessory dwelling unit. And one can understand why. That it poses additional regulations on them that they have to comply with. They have to update their registration every year. They have to report a covenant. They have not proposed an accessory dwelling unit. That's not on the table. And in fact, they haven't proposed anything different at all from last year. I think we would not be here today if the Brugge's and Mr. Trout and RWA had said, hey, we would like to work with you to find some alternative that you would be okay with. The Woods are reasonable people. They have no ill will toward the Brugge's here. But how could the Brugge's expect a different result when they literally submit the exact same application? So again, Your Honor, Mr. Examiner, I apologize. This is the same application, same law you're applying, same set of facts. There has been no material change that should affect your analysis. This case is a foregone conclusion. We would respectfully ask that you deny the side yard setback variance requested today. Thank you for your time and attention.
Thank you, JP. Mr. Burley, appreciate it. Mr. Trout, are you ready?
I am. Thank you. Mr. Sturkey, and I'll keep this brief because I think we've spent a lot of time on this and talked about the majority of issues here. What I find interesting is that throughout this hearing, there's seemingly been this threat from the Woods and Mr. Burley that saying that you cannot consider this, you're not allowed to consider this application. That's just simply not true. there is a plethora of case law out there, as Mr. Burley has suggested and stated. There's a ton of it out there. I gave you the case law on when res judicata does not apply. The Ohio Supreme Court has specifically stated a change in the facts in a given action, which either raises a new material issue or which would have been relevant to the resolution of material issue, does not, that means res judicata does not apply. Any of that. I've given you additional case law that states that res judicata doesn't apply. Here in this specific instance, and just to clarify, I've not argued that the analysis of whether a variance should be granted, I'm sorry, the elements of whether a variance should be granted has been changed. That's not the scenario. The scenario is that the underlying zoning code, the law that applies to zoning, has been changed in such a way that it is a change of facts that raises new material issues, and it would have been relevant relevant to the resolution of the material issues in the prior application. Res judicata issue preclusion simply just does not apply. There's a lot of case law out there. There's at least a couple cases in which there's an analysis of zoning code changes and whether res judicata applies. And it really comes down to whether the material rights have been impacted or would be impacted by the zoning code change. And the fact here is that they are. Everything that the Brugge's are wanting to do, save for that 1 foot connection, is allowed under the Cincinnati zoning code. You've heard it from Mr. Burley, you've heard it from the Woods, that they cannot stop them from doing the ADU, from building it taller, from building it closer to their property line. The only variance request we're asking here is to be able to connect it and have, and frankly, like we said, it's not as close to the property line. It won't be built as close to the property line as they're allowed to do. It's less invasive. That is the change in law. What the Brugge's are requesting is, without that 1 foot connection, anything that the Woods have said is completely irrelevant, because as they acknowledge, the Brugge's would be allowed to do it. One thing that I want to again just restate is that Mr. Burley in his closing said they're not applying for a height variance. It's accurate because they don't have to. It's the connection, and then they're within what they're allowed to do from a height variance, from a setback, from a height and all other requirements. They fit within those means. They fit within the zoning code. It is just that setback that is created by the connection itself. They don't have to apply for a height variance. One thing that I think is important is that you didn't hear any legitimate reason as to why this connection impacts the Woods. You heard two reasons: that it'll aesthetically look less appealing. When, I mean, the drawings themselves, the architectural renderings show that this will actually be very beautiful. Aesthetically, it's going to look fantastic. You haven't heard any legitimate reason from them as to how this connection, the connection itself, impacts them, because it doesn't. Circling back to the other project, the one across the street, the 3440, I believe it is, Principio. The fact that the connection itself is different in nature than what the Brugge's are requesting has no relevance. Mike touched on this. I touched on it earlier. It's just the simple fact of the connection itself. The Woods did not oppose that connection at all. They showed up to the hearing. They didn't oppose it. I asked you to consider, why then are they opposing this one? The connection isn't what bothers them. They simply just don't want to agree to anything here. And that's fine. They have their right to do that. But it is the connection itself that mandates or requires the variance. It is not the connection, the type of connection. It is not that it's enclosed. It's not that it's open. As I said earlier, to just give an analogy, the moment that you put a 2x4 between the home and the other existing structure, that is connected. That is when the variance is necessary because of the setback requirements. One of the things that has been stated is that there's options or opportunities for them to expand elsewhere on their property. You heard from RWA why that can't happen. There is no other legitimate spot. You heard about the sewer easement. You heard about other issues. This is the spot. This is the location to which they can expand their home. This is it. This is the only spot that they can do that. Certainly the only practical spot. I find it important one more time to highlight Mr. Munzel's staff report. I thought that it was very well put together. It was very well reasoned. He went through the entire analysis of whether to grant a variance, all of the elements. He analyzed all of these similar homes that have been cited in the application. Ultimately, he made three statements that are important to this scenario. And the first that I highlighted before was that while the proposed addition is not an ADU, the text amendment is considered a substantial change to the zoning code impacting the overall review. He already said that this is a substantial change. This is why res judicata or issue preclusion does not apply. He says that the proposed side setback variance allows for a reasonable addition to be built on the existing lot of record. He says this is a unique situation and a strict interpretation of the code would be unreasonable and would result in practical difficulty in construction of functional addition. You heard statements today from me, from RWA, from the Brugies that all establish exactly what Mr. Munzel said. It all falls in line. Ultimately, Mr. Munzel said the proposal is compatible with the neighborhood and will not substantially negatively impact nearby properties. You heard from the Woods that they're saying both, that A, it doesn't impact others as much, and it doesn't impact them at all. So in their eyes, they're the only ones impacted by this, and they're the only ones who should have a say. They disregard all of the other people who are supporting this in saying that they're the only ones impacted. That's important to the analysis too. Ultimately, Mr. Munzel recommended that the project be approved, that the variance be approved, and we would ask that it be approved for the same reason that the 3440 was approved, and for all the reasons that we talked about today. For all the reasons that we cited, for all of the factors that we cited and discussed, for all of the reasons and factors cited in the RWA application, which is substantial. There's a lot to it. It's very well thought out. We ask that you approve the Brugies variance for the setback variance so that they can connect this addition to their home. That's all.
Okay. Thank you, Mr. Trout. All right, we'll leave it at that. I want to thank everyone for their time and their testimony. This is obviously a very, very tricky decision, and you all have not made my life easier over here, but that's because we have, property owners that really care, good architects and good attorneys on this case. And so I want to commend everyone for their work on this, and to the attorneys for their professional presentations. I have a lot to review here, including some case law, as we've talked about. And so I'm gonna do everything I can to get this out to you in the next couple of weeks. But if it goes beyond that, feel free to send me an email and contact me, and I can give you a status update on exactly where I'm at with the decision. But it's going to take a little bit of review and research. As soon as I finish that decision, I think everyone in this room is familiar with the process, but I will put it into a PDF. I'll email it to everybody who's in the hearing here today. You all will have a copy of that really just moments after it's complete. And then, of course, that will be the time when the 30-day window for appeal starts. So if any party is interested in appealing this decision to the Zoning Board of Appeals, that will be an option, but you'll have a 30-day window to do that if you would like. Any questions about anything that's happened here today or the process at all?
Mr. Sturkey, if I could just add one thing, if you find that it would be helpful or prudent, I would be happy to submit to you some additional case law to review as well. I cited the standards, it won't be that difficult to find, but I would be happy to send you some case law too, or answer any other questions that you might have.
So now that the case is closed, I can't take in any additional evidence or arguments or submissions from either party. And so I'll just have to dig into it myself and rely on what I can find and what's been submitted thus far. But I appreciate that offer though. Any other questions? Okay. Well, thanks again, everyone, and hope you all have a wonderful day. We are adjourned. Take care.
All right.
Thank you.
Thank you.